Hello, fellow law nerds. Welcome to another summer session of Boom Lawyered, a Rewire News Group podcast hosted by the legal journalism team that is excited for you to join us for our second annual edition of Summer Sessions. I'm Rewire News Group's co-chief content officer, Imani Gandhi.
And I'm Jess Pieklo, Rewire News Group's other co-chief content officer. Rewire News Group is the one and only home for expert repro journalism that inspires you to keep reading banned books this summer. And the Boom Lawyered podcast is part of that mission. So a big thanks to our subscribers and a welcome to our new listeners.
And viewers, because Boom Lawyered is back on video, baby!
Yeah! All right, let's get into it. During summer session, Imani and I take a look at some of the biggest issues of the zeitgeist and, with the help of a guest each episode, break them down for you. This week, we're digging into the First Amendment, specifically what the Roberts Court is doing to rewrite the relationship between church and state for the benefit of primarily Christian conservatives in this country.
Just look at Mahmoud v. Taylor, for crying out loud.
Right?
We covered that case quite a bit on the podcast, and I still don't think it's settling in for folks just how much damage Sam Alito and the conservatives on the court did in that case.
Mm-hmm.
That's the case involving LGBTQ book bans, where the court's conservatives basically blessed them at the expense of the First Amendment. The court said that parents had the right to opt out their children from any storybook hour featuring LGBTQ plus content. Or what about St. Isidore of Seville v. Drummond, where the court came this close. So close to endorsing Oklahoma's efforts to create, for the first time ever, a state-funded religious charter school. The court ended up affirming, thankfully, the Oklahoma Supreme Court's ruling that no, you can't actually do that.
No.
And that's because Justice Amy Coney Barrett, who is on my shit list, by the way, had recused herself, likely for being besties with one of the guys pushing for the state-funded Catholic school. But still, the First Amendment is a mess.
Boy, is it. And we couldn't think of anyone better to help us understand this church-state landscape right now than Professor Elizabeth Sepper. She is the Krillin C. Payne II Professor of Health Law at the University of Texas at Austin and a nationally recognized scholar of religious liberty, health law, and equality. She has written extensively on conflicts over religion, speech, and sex equality. Professor Sepper's research has uncovered and analyzed corporate structures that claim religious identity in unusual and challenging ways, like zombie Catholic hospitals to government-owned religious institutions.
And Liz was one of our very first guests on our very first podcast together. You remember our little baby podcast from 2014, RJ Court Watch? Liz was one of our first guests. That was a decade ago. So Liz is an old friend of the podcast.
Old friend of the podcast. Welcome back to the show, Liz.
Thanks for having me. Proud to be an OG.
Oh, absolutely. It's wonderful. And what a fantastic return to video this season to have you as part of it. So let's start off with a level set here, okay? Do you agree with the premise in the upfront that the First Amendment is getting a rewrite under the Roberts Court? And if yes, say more. And if no, what are we missing?
Yeah, so what we've seen is we've gone pretty rapidly from a First Amendment landscape where we had what was known as a play in the joints between the free exercise clause of the First Amendment and the establishment clause of the First Amendment. This basically meant states could accommodate religion without offending the establishment clause, but they could do things to protect against the establishment of religion without offending the free exercise clause. And what we've seen the Supreme Court do over approximately the past 20 years, but on an accelerated timeline in more or less the last 10 years, is to turbocharge the free exercise clause and essentially erase the establishment clause from the Constitution. So we're seeing lots and lots of free exercise claims brought by really powerful majoritarian religions, and they're winning. And when states say, well, we can't accommodate you because we're going to run into the establishment clause and impose religion on our citizens, the Supreme Court says essentially, so what?
Well, that's kind of grim. And I'm thinking about that as like a parallel, the joint of the exercise and establishment is a really good visual. And I'm thinking about the way that cases in that First Amendment lane have come up, specifically Trinity Lutheran and Kennedy versus Bremerton as sort of two like anchor points in that, right? Trinity Lutheran was the playground case where now we start to see more funding of states into religious institutions. And then Kennedy versus Bremerton, we've talked about on the podcast a bunch, the Let Coach Pray case. Are there others in that sort of, parade of horribles in new precedent that you would point to that have really shifted the landscape?
Right. So the constitutional rule that states, school districts, cities were working with was a rule that said that governments couldn't fund religion. And that had been the rule for quite some time. They could offer sort of secular payments. So religious hospitals, for instance, provide medical services. State programs can pay for those medical services.
Sure.
But the government couldn't give money to churches, right? They could give them tax exemptions, but not fund them directly. They didn't fund religious schools or sectarian schools directly. And then we get Trinity Lutheran, which really looks like nothing. It's a state program over playground resurfacing funding. But you have a church there who makes a request and says it violates the free exercise clause not to give us this money.
Mm-hmm.
And what we know about money is it's fungible. So if you give a church money for a playground, it doesn't seem like that big a deal. But then they have more money to pay for proselytization or to pay for minister salaries, for example. And that was sort of the justification.
Mm-hmm.
So in Trinity Lutheran, the Supreme Court says, well, no, the free exercise clause requires that if you offer this money to private entities, you have to offer it to religious entities. You can't discriminate based on their status. But it had a hilarious footnote that was widely mocked. It said, well, this is just about playgrounds. We're not talking about important things.
Right.
Lo and behold, a couple years down the road, we have another case known as Espinoza that involved school funding in the state of Montana, school vouchers.
Mm-hmm.
And so there the Supreme Court says, well, no, it violates the free exercise clause not to give school vouchers to religious schools if you give them to secular private schools. And so what we have here is a problem essentially of discrimination, and you have to include religious schools. And so it says, but this is just about status. It's not about use. So if they were going to use it to pay for ministers or use it to pay for religious instruction, then we might have a constitutional problem. So trust us, this is the rule. And just a few years down the road in Carson v. Macon, you then have a challenge to Maine's, the northeastern states all end up creating really bad constitutional law. Maine has this weirdo program where it provides money that for public schooling, you can either go to your local public high school, or in many places there is no such place, or in some places. And so they'll pay for private schooling. And there you had parents who wanted, and they included, Maine was willing to pay for that schooling in religious schools, but not in sectarian schools. So they wanted to avoid that religious instruction. They wanted to avoid discrimination on the basis of religion. And the Supreme Court said, well, no, it's not just about religious status. You have to include religious entities even when they are teaching religion and doing religious things if you fund private schools.
Can you explain the difference between a sectarian school and a religious school, just for people who may not understand?
Yeah, it's a little bit slippery in the case of Maine, I will say, right? So the basic idea was that you could have a school that had a religious identity, but it was willing to accept children into the program who came from all kinds of religious backgrounds. And it wasn't doing things like requiring affirmance of Catholic teaching or requiring attendance at Catholic Mass.
Okay.
Sectarian schools instead would do those things.
Can I turn to Kennedy versus Bremerton for a moment? That's the Let Coach Pray case. And we talk about this case a lot because it really is sort of indicative of the way in which the court is essentially, and pardon my French, making shit up in order to make law that benefits Christian conservatives. And in that case, we had Neil Gorsuch essentially saying, oh, this was just a private prayer session, right? This guy would gather up a couple of his players and in the darkest recesses of the locker room would hold a little mini prayer session. And then here comes Sonia Sotomayor in her dissent, like, excuse me, Neil, that is not the case. And then actually included an illustration of what the prayer looked like. And it was legitimately like a Friday Night Lights scenario, right? Where all of the teams are in the middle of the field with their helmets raised up high to the Lord, and they're all praying together. And so it was very indicative of this court's willingness to sort of make up facts or to ignore facts that don't suit them in order to promote a particular policy. Does that concern you?
Oh, sure. I mean, that has been the line in these religion cases. I mean, some of it comes, or religious adjacent cases in some cases, sometimes they're reinvented as speech cases. But, right, I think we're seeing a couple things, right? First, and I'm sure we'll talk about this, right? The kinds of litigation shops bringing these cases before the court are part of a very organized and extremely well-funded conservative Christian nationalist movement. So they really want to establish a certain form of religion in the U.S., and they get impatient. And so, right, Bremerton was a case where Coach Kennedy was praying with students. There was a long record showing that for some time he was requiring prayer in the locker room, right? They tamped down on that, but he kept on praying, and he refused the various accommodations that were offered to him to allow him to pray separately or privately in ways that didn't interfere with students and their parents' exercise of religious beliefs. We've seen this pattern before, right? We know we've seen a series of cases from public accommodations. So web designer open to the public who has never been asked to do a same-sex wedding website, but nonetheless shows up to the court. I mean, beyond that, there are a series of litigation in this area where you have people, for example, who never did anything, right? Photographers who had never, ever photographed any wedding, let alone a same-sex wedding, right? And so they shouldn't have been allowed before the court, but they were, right? There was a series of sort of fictions constructed, a story told, and the Supreme Court is impatient too. So it doesn't wait for the facts. And I think we see that in Mahmoud as well, right? The factual record wasn't really developed, and it allows the court to make up whatever, or paint whatever picture it wants to paint of what's going on.
And just for our listeners, the case that she's talking about, the web design case, is called 303 Creative versus Elenis. And if you've been a longtime listener of this podcast, you know that Jess and I fully lost our minds.
Yeah, we flamed that case pretty hard. You make such a really good point, and I want to build on it because I know Imani wants to talk about Mahmoud. Also, the well-funded and well-organized legal advocacy network behind this, and I think the Kennedy case is such a good example of this. Not only do they love to craft the facts and narrative that a court has already sort of signaled they're willing, like Justice Alito, I think, is the best at signaling what he thinks the next case should be. But they've really, I think, to our detriment, but their credit, honed in on the lawmaking as narrative at the Supreme Court, and they find a pinched plaintiff. So not only do they make up facts, but they're really good at creating a persecution narrative around their plaintiff that the court is already predisposed to believe. And that is another through line, I think, in these cases, is the institution is being mean to Christians. Right? Like that was 303, that was Masterpiece Cake Shop, even Kennedy here, and frankly, in Mahmoud versus Taylor.
For sure, right? This is a court that is inclined to see hostility against Christians everywhere. I mean, Justice Alito in particular. But I think Justice Kavanaugh is actually showing a lot of that tendency, thinking that everything is sectarian or religious discrimination. And he's, of course, particularly attracted to a narrative of anti-Catholic, I think, discrimination.
So can we shift to Mahmoud v. Taylor for a moment? Can you walk us through how that case really shifted the First Amendment landscape?
Yeah. So the challenges from parents who don't want their children exposed to or read from essentially lower elementary school level storybooks that feature LGBTQ characters or gender identity experiences, usually of just children or same-sex marriage. And so it results from a political battle. And these parents, conservative parents across various different conservative religious beliefs and non-religious parents, I will say, they come to the school board, they attend meetings, they protest, they seek opt-outs. For some time, they get opt-outs, but those apparently became too numerous and were going to be unworkable for this school district, one of the biggest school districts in the country, if not the biggest, and the most diverse, I believe. So the school drops the opt-out policy, says we can't do that. We're going to have these books in the classroom. They can be taken down by students to read. They'll be on the shelves. Students could choose them for read-alouds, or teachers can choose them for read-alouds. And that's basically where this comes from. And then the challenge to the Supreme Court is a challenge that essentially says, okay, we lost in the political process. We lost. This has always been a political issue. This has always been a local issue, right? Mm-hmm. Federal courts have not played this kind of role over curricula of public schools. It's just true that left and right, federal courts, state courts have rejected these kind of challenges on free exercise and other grounds. If you send your kid to public school, you have to essentially accept the curriculum that you're getting from the school. So the dramatic change from Mahmoud is that is no longer the rule, at least for some parents, right? That simple exposure to materials or teaching that offend your religious sensibilities can mean that your kid gets an opt-out. The standard that the Supreme Court looks to is one that says whether the material substantially interferes with the religious development of a child. And if it does, then it goes down to strict scrutiny. And it looks like a level of strict scrutiny that's really going to favor religious objectors when they object to lots of material, not just LGBTQ storylines.
Right. And as you said, parents can object to a lot of material now. So what do you think the impact of the decision is going to be? Certainly the dissenters in Mahmoud made points that there could be a parent who disapproves of learning about, women in history because women shouldn't be in history or shouldn't be doing anything besides baking bread and being pregnant. So what do you think the impact could be?
I mean, one place to look is just what we've already seen, right? What did courts already reject? And one of those is the representation of any material that shows women achieving goals outside of the home. We've seen lots of objections, and you can think of how impoverished elementary school education would be without this. We've seen a lot of objections to anything around magic. So sorcerers, wizards, dragons, everything.
No, that's the devil's stuff, Liz.
I know, but it's what children love. Right, it gets them to love reading and thinking and imagination. There are parents who have objected to materials that foster critical thinking, creative writing, or invite imagination outside the limitations of scripture. Not entirely sure what that means. But we can just also look at some of the parents that were in the Mahmoud litigation, right? You had conservative Catholic parents who said, look, we object to anything that shows a marriage that's not a lifelong marriage between a man and a woman. There are lots of books nicely now, this was not true when we were growing up, that feature blended families, right? Families where someone has gotten a divorce and remarried. And, that is nice. It creates a welcoming culture. Those are going to be subject to attack. The Muslim parents in this case say they object to any depiction of, I don't know that I quite believe this is genuine, but they object to any depiction of romantic relationships. And if that is a genuine religious belief that they hold, they should also object to all of the books that feature marriage, right? Every fairy tale, Cinderella, Little Mermaid, and so on. So, right. But I think beyond that, we can think creation science versus evolution as a very clear one that may be in the hopper eventually.
Do you think that there was any sort of cynicism involved in making the Muslim parents the named plaintiffs of the case?
Yeah, so you will hear conservatives, right? When I say this is an enormous win for Christian nationalism in our country and a step forward for Christian nationalism, people will say, aha, a case called Mahmoud, you must be wrong about that. And the truth of the matter is that very conservative religions share some basic beliefs, in particular about gender and sexuality, right? So they will find common cause. But let's be clear, we know what side the bread is buttered. And when it comes to a conflict, say you have Christian conservative parents who don't want to see Muslims or Jews depicted in elementary school books, they are going to be the winners here.
Mm-hmm.
And they are going to be the ones who have conservative litigation shops like Alliance Defending Freedom and the Beckett Fund behind them.
Yeah, so cynical and just so underhanded. And on that note, I'm going to turn us to St. Isidore's because that feels appropriate in some ways. That was another case from the term that really had Imani and I concerned. It was like this perfect storm of conservative causes funneling money away from public schools and into religious ones. Except in this case, as Imani suggested in the upfront, Oklahoma wanted to take it even one step further. So can you explain what happened in St. Isidore's and sort of what was going on behind the scenes for Oklahoma to think, you know what we really need right now is a state-run Catholic charter school?
Yeah, well, I would say it's not exactly Oklahoma who wanted this, right? This is sort of a fight within a state, right?
Yeah.
So you have the Oklahoma charter board fighting essentially with the attorney general who says, look, this is unconstitutional. And what is unconstitutional is here you had again, a school that does not exist, that has no students, has never taught anyone. It should sound familiar to 303 Creative not having done wedding websites and like. So you have a claim from a Catholic entity that wants to create a charter school. Now, the thing about Oklahoma's program is charter schools are public schools. They can only be established. I mean, the statute uses that language, established by the state of Oklahoma. They are not only labeled public schools, but subject to lots of the requirements for public schooling. They have to be free. They have to let everyone in. They have to comply with all sorts of regulations, submit themselves to supervision, and the state can unilaterally close them. So these don't look like private schools, right? And the Oklahoma Charter Board nonetheless said, you know what, we're going to look to all that Supreme Court case law on the vouchers and say this is just like vouchers, right? So the difference, though, in addition to the public nature, is the amount of money, right? This is sort of the next step, not only for the Christian nationalist movement, but for libertarians like Cato that have been engaged in a persistent attack on public ed. And so the idea is, well, now we don't just need charters, which undermine public schools that are neighborhood schools, right? And have democratically elected school boards, but rather we also need the vouchers, right? And now we want to say, the amount of money you provide to public schools, you have to provide to religious schools on equal terms. And that's really what was at stake in Drummond, where we had this near miss, 4-4, just because Justice Barrett was recused.
I think this case is such a clear example of the way the conservative legal movement scaffolds its work and its policy building. So what's next for this issue? We know that they're not going to take a 4-4 punt functionally. Do you have any idea what's going on? Are we going to see another attempt by Oklahoma or another state to try and implement this kind of structure to get it to the court so that they get that 5-4 or 6-3?
For sure, right? Nearly every state, I think it's 47, have charter schools, right? So, and it's very low cost, as we can see, right? This isn't a real school that's trying to become a charter school. It's also an online school, and it doesn't exist. Right. So should be very low cost to mount another challenge. The question is, how quickly can it be done? How quickly will it go back before the Supreme Court? And, Amy Coney Barrett was recused because of the participation of one of her we think.
Yeah.
We aren't told, but because of the participation of one of her Notre Dame law school colleagues who's a big activist in this area. And all they have to do to clean that up is simply take her out of the equation going forward.
Man.
So will it be 2 years, 3, 5? Hard to know.
And I mean, we don't even, with who knows with what's going on with the Department of Education anyway, right? Like that's a whole new layer in all of these conversations is, sort of what the hell's going on with the feds anyway. Wow.
Yeah, it's a mess. Do you have any sleeper issues or cases on your radar that you'd care to share with our listeners?
One sleeper case that seems to be sort of limping out that I've been following involves what James Nelson, who's at the University of Houston Law School, and I have looked at, which is government religious hospitals. So we've uncovered a number of what look to be largely unconstitutional arrangements that states and university systems have entered into, primarily with Catholic hospitals. And there's a case out of Maryland involving the University of Maryland medical system and a plaintiff called Jesse Hammonds, who's represented by the ACLU. And Jesse Hammonds was denied gender-affirming surgery sort of last minute by the University of Maryland St. Joseph Hospital. And why? To conform to the religious beliefs of the hospital.
Mm-hmm.
This is an entity that is pretty clearly, I think, a governmental entity. And so he brought Establishment Clause claims, anti-discrimination claims, and the state of Maryland raised the Religious Freedom Restoration Act, right, in defense. A state saying it would violate the religious freedom of the institution to be subject to anti-discrimination law. Really, really dark as an idea. I mean, I guess a fun academic topic if you like those kind of puzzles. But for real people, right, potentially devastating. Now, the courts have sort of sidestepped. This is not going to go to the Supreme Court. Hammonds did win on the anti-discrimination claim. The court said, Maryland, what are you talking about? You can't raise religion. But I suspect these kind of issues will come up because we're seeing so much blending of church and state within these programs.
I was laughing so hard at Imani's and I's face and our reactions when you said that Maryland raised the RFRA claim, because we both did this like wild grimace, like what? So for listeners who may have missed it, that is a really alarming development that a state would claim a religious interest in a fight.
Yeah, absolutely. Right. I mean, states aren't supposed to have religion. That's the whole idea of the Establishment Clause.
Okay, well, so what's next for the First Amendment and the Roberts Court then, Liz? I saw some reporting in The Hill that conservatives hope that it's this 10 Commandments fight in the schools, which is starting to come up again. And it feels like I'm old enough to remember this is a thing that like comes up every several years, but maybe their insistence is this will be the final bite at that apple. Do you think it's going to be something like that? Is it, another state charter religious school? What do you think will be the next biggie before the court?
I mean, the 10 Commandments issue is clearly brewing. There's clearly, again, an appetite on the conservative legal movement to get that before the court. We've seen...
What's that about? That's so weird.
Yeah, I mean, we've seen Louisiana, Texas, Arkansas, others. They're being challenged right now. Texas, in fact, passed mandatory in every classroom 10 Commandments bill. I don't know if this Supreme Court is the right Supreme Court in one sense. And the sense is this. The versions of the 10 Commandments that are required to be posted are Protestant. They say that graven images basically violate God's commandments, and that is deeply offensive to Catholics. We love our graven images. We love them.
Oh my gosh. So the Reformation may save us. That's amazing.
It launched a lot of wars. Maybe we get a war at the Supreme Court about whether it's worthwhile to go with it.
Oh, I guess I didn't realize that the 10 Commandment bills were pushing Protestant versions of the 10 Commandments, but now that's a wrinkle that I kind of love as creating some, turf fights within the overall conservative legal movement. That's fantastic.
I love that they're going to go the way of Ireland from back in the day, right? When Protestants and Catholics were just like, we're going to bomb each other until somebody wins.
We'll just partition like India, Pakistan. religion, right?
Good grief.
Oh my
I
gosh.
have another question for you that just sort of popped into my head. One of the things that's always bothered me about religious cases is the way in which the court just sort of accepts that whatever a litigant before them says is a sincerely religious held belief as a sincerely religious held belief. Is there ever going to be a world in which the court questions the nature of the belief, or are the beliefs going to get increasingly more ridiculous and we're just going to have to live with it because you can't question somebody's faith?
What courts are supposed to do when they have a request for religious exemption, either under the Free Exercise Clause or under RFRA, the Religious Freedom Restoration Act, they're supposed to say, is this actually religious? Is this sincerely held? And they're supposed to ask whether there's a substantial burden on religion. What we know is courts are not really willing to think about whether something is religious. We've seen a couple examples actually in the vaccine context, right? You had people who would say, I can't wear a mask because of my religion, and God says we're all created in his image, so I can't cover my body. And those largely got laughed out of court. Some people think that's wrong to look into religion. You could also think of that as a sincerity problem. Sincerity is sort of having a heyday in the legal academy because in our favorite case, Hobby Lobby, the Supreme Court turned substantial burden into something less than substantial burden, basically saying if you believe it, if you believe it's a substantial burden, it may well be a substantial burden. But in any case, if you're facing a fine, well, that's a substantial burden, right? So there was a lot of turn to like, we could look at sincerity. Courts don't look at sincerity unless you're a minority religion or unless you are someone who's vulnerable in other ways, right? Someone who is incarcerated or an immigrant or a criminal defendant, at least in the non-white collar context, I would say. So I do think, right, there's not too much to be done there. But I do think that if we saw sincerity really used, we would see a lot of, well, conservative Christians are always sincere and minority religions aren't. So it creates this partisanship. I do want to say one thing related to the vaccines and Mahmoud, to connect it to Mahmoud, is the record in Mahmoud, to the extent there is one, is that a lot of the objections to the books came not motivated by religious belief, but motivated by political conviction, right? That people just didn't want these books for reasons of opposition to LGBTQ equality politically. And what worries me about Mahmoud, beyond like the immediate religious objection and religious favoritism, is it kind of looks like vaccines. We're going to see people really leaning in, as they have been doing, I think, since Obergefell, into the idea that all opposition to gay rights is religious and therefore must be treated with respect. And we know that's not true. And we know that lots of people's politics now, as a matter of fact, are driving their religious affiliation. So this just creates more of that, I'm afraid.
No, I think that's such a smart point to end our conversation on, because in Obergefell, both John Roberts and Sam Alito absolutely teed up that reality, right? In equal parts. For Sam Alito, opposition to marriage equality is, writ large religious discrimination if you're trying to question it. And for, same thing for John Roberts, so much so that he read his dissent from the bench. I'm old enough to still be mad about that.
And just for our listeners who may have forgotten or may not know, what is Obergefell v. Hodges, Jess?
Oh, sure. That's the Supreme Court case that legalized marriage equality across the country. Liz, thank you so much for helping Imani and I make us smarter, our listeners smarter, and to be part of this season of bringing Boom Lawyered back to video. This has been phenomenal. Thank you.
Thank you both. You're awesome. Keep doing what you're doing.
If folks want to see or read or learn more about your work and what you do, where can they find you?
They can easily Google Elizabeth Sepper, University of Texas. They'll find everything there, links to articles and so on, or they can find me on Blue Sky at L Sepper.
Her Blue Sky is phenomenal. Definitely go check it out. She most recently posted a photo of some art Art is doing some work there that the University of Texas has posted that was Supreme Court beachside. Imani, would you care to see Sam Alito in his trunks?
I can't say that I would. I cannot say
You
that.
haven't lived, Imani.
Then it's okay. I haven't lived. I'm okay with that. Once again, Liz, thank you so much for joining us. This has been a real treat, and I think it will be a real treat for our listeners. And again, it's really exciting to get back together after, having our first conversation literally in 2014.
And I think that whole conversation was Hobby Lobby, man.
It was. We were obsessed with Hobby Lobby at the time, with good reason, because look where it's led. To our listeners and viewers, thank you so much for joining us for this first episode of Summer Sessions. We will be dropping episodes for the rest of the month, so please make sure to check our website, rewirenewsgroup.com. Please subscribe to our YouTube, right? Check out Rewire News Group on YouTube. And as always, our social channels are popping with amazing content: Instagram, Threads, Blue Sky, and TikTok. If you want to talk to either Jess or me, we are both on Blue Sky, hopefully not looking at Sam Alito in his swimming trunks. I'm Angry Black Lady on Blue Sky, and Jess is Hegemommy, Hegemommy. And on that note, Jess, what are we going to do?
We'll see you on the tubes, folks.
We'll see you on the tubes, folks.